So welcome everybody. I think we're just going to jump into it now rather than wait, and we'll let people sign on while the discussion is in progress. Let me count us in. 3, 2, 1. All right. Welcome, friends. Thank you for jumping on with us. As you know, we've got the great Adam Klasfeld back with us today of All Rise News, gavel to gavel coverage of really the most consequential legal cases of the day. And he was down in Tennessee today for the ongoing saga of Kilmar Abrego Garcia's motion to dismiss his criminal case based on vindictive prosecution. Today was kind of the hearing we've all been waiting for. It was an evidentiary hearing. People testified, and I am so grateful that we've got Adam to kind of bring us into the courtroom and tell us what went on. So, Adam, welcome. Thank you for joining us, and tell us what happened today in court.
Thank you very much, Glenn. So today was a significant day for a number of reasons. As you said, this is the vindictive prosecution hearing, and the fact that the hearing is taking place is in itself a victory for Kilmar Abrego Garcia. Criminal defendants do not have that as a right. They have to win it, and he won the right to this evidentiary hearing. The other significant thing about the hearing even taking place today is that Kilmar Abrego Garcia walked into court with his wife, with his activist colleagues who accompanied him into court. That happened because he won rulings releasing him from criminal and immigration custody. So this is the first time that happened in his federal criminal court hearing, and that backdrop deserves to be said. Now, as to the substance of the hearing, when I said that he won the right to this hearing, and that in and of itself is a victory, that victory entitles him to shift the burden to the government, which needed to prove they had to overcome the presumption of vindictiveness by putting on witnesses. Kilmar Abrego Garcia, his defense team called witnesses. They called witnesses at the top of Main Justice, not Pam Bondi, but Todd Blanche, who made statements on Fox with Laura Ingraham that caused this hearing to a large part because he told Laura Ingraham that the investigation into Abrego began because a federal judge questioned their decision to spirit him out of the country last March. That the federal judge found was striking enough for this hearing to begin. But Todd Blanche didn't explain those remarks. He resisted that subpoena. He was not here today. Also not here today was Blanche's deputy, Akash Singh, who was in close communication with the former top prosecutor in the Middle District of Tennessee, Robert McGuire, who was one of two witnesses today, along with the special agent in charge of Homeland Security investigations, Rana Sood. Those were the two witnesses. But Kilmar Abrego Garcia's attorneys made clear before this hearing ever began that bringing lower level people isn't going to cut it because it's the government's burden. Now, let me tell you what did happen. That's all the context for what happened today. Their testimony, Ms. Sood's testimony and Mr. McGuire's testimony, is they made an independent decision that was uncompromised, unsullied by Main Justice. Rana Sood said that she learned about this 2022 traffic stop that formed the basis of the smuggling allegations against Kilmar Abrego Garcia from a small local publication known as the Tennessee Star, a conservative publication, on April 21st. And it's apparently just a coincidence that that was after the Supreme Court's ruling ordering Abrego's return, that she found it from the media, she looked into it, and she passed it on to McGuire. That's her story. On McGuire's side of the ledger, he says that he brought the case because this case was brought to him by Ms. Sood. He looked into it. He made an independent decision. Sure, he communicated with Todd Blanche's deputy, but he was calling the shots. Then came cross-examination. The first cross-examining attorney for Abrego was and Roscoe Dean. Now, I'll tell you a little bit about Dean's background because it's important a little bit later. But he questioned Ms. Sode, and he said that he pointed out that this Tennessee Star article followed nationwide coverage of the body cam footage of the 2022 traffic stop on which this prosecution was based. That CNN had covered it. It'd been national news, and Donald Trump himself had commented on the video in kind of undermining her idea. Well, I read this article from the Tennessee Star that was forwarded to me. I don't know who forwarded it to me. And so that story doesn't make sense. On cross-examination of Robert McGuire, we heard from the former head of the federal defenders of New York, David Patton, because Kilmar Abrego Garcia has an all-star legal team. And what David Patton pointed out is that Robert McGuire was holding on to his job at a time of a nationwide purge of people inside the DOJ. There were the January 6th prosecutors. There were the special counsel prosecutors. There were the people in the Southern District of New York who resisted the dismissal of the case against Eric Adams. And there was also Rob McGuire's criminal division chief, Ben Schrader, who believed that Kilmar Abrego Garcia should not be prosecuted and resigned on the day that Kilmar Abrego Garcia was indicted.
I don't want to break your flow because this is fascinating. What form did the evidence take, Adam, of Ben Schrader's, disagreement with the Abrego indictment?
So that came during the cross-examination and even to a certain extent during the direct examination of Rob McGuire. Now, Rob McGuire and Ben Schrader came out are friends. As a matter of fact, to this day, Rob McGuire has wonderful things to say about Ben Schrader, saying that he's a great prosecutor, he's an honorable man. He came to a different opinion about the merits of the case, and this came out today. This is news from today. He memorialized the reasons why he didn't think this case should be brought in a memo that he wanted to be passed to, quote, DC, because he knew that DC was keenly interested in this case and he wanted the reasons why he thought it shouldn't be brought forwarded to them. McGuire testified he did not forward the declination memo, but he passed on that Ben Schrader did not want this case to be brought. So that's one pretty big revelation. Another big revelation.
Let me just interject in real time or I will forget. Ben Schrader used to be a prosecutor at my former office, the DC U.S. Attorney's Office. I think highly regarded, but let me tell you, over the course of my 30 years as a prosecutor, had plenty of disagreements, differing opinions within the U.S. Attorney's Office, where I would sit down with fellow prosecutors and we would debate and discuss and come to different conclusions about a particular tactical or strategic course to take in a case, including whether to indict or not. I never had anybody resign over a disagreement that we were having about tactics or strategy. So I find it pretty dramatic that when Ben Schrader, somebody highly regarded, I'll agree with Mr. McGuire here, resigned after, he was apparently overruled as the chief of the criminal division in the Middle District of Tennessee at the time. He was overruled and Abrego was indicted. I find that to signal something more than just a disagreement over tactics and strategy. But that's my 2 cents. Please continue.
Oh, absolutely. This wasn't, and to be clear, McGuire himself freely acknowledged that Ben Schrader didn't think the case should be brought because he didn't think there was a case. He thought that this was being brought for politically motivated reasons. That was something that was previously reported, but confirmed today in federal court by Rob McGuire. And as a matter of fact, he said that this was all memorialized in a memo that hasn't been made public. Rob McGuire ultimately said he made the decision to move ahead because he believed in the case, he believed in the merits of the case. But Dave Patton had grilled and interrogated that proposition. He pointed out that the day that he got the case, that Rob McGuire got this case, it was April 27th. It was after the Supreme Court said, bring Kilmar Abrego Garcia back to the United States. And it was maybe a couple of weeks after that. And Rob McGuire on Sunday, April 27th, he gets a case. Hours later, he receives an email on Sunday night from Todd Blanche's deputy, Akash Singh, informing him of the person who had become the key cooperating witness against Abrego. McGuire testified he didn't know about this witness until he received this Sunday night email. So take a moment to step back to what this means. On the one hand, you have McGuire saying, I made an independent judgment. I followed the facts wherever it led me. And on the other hand, he is saying, 2 hours before I learn of this case's existence, I am getting Todd Blanche's aide telling me who's going to become the lead cooperating witness against Abrego, a man that I never heard about. And he thinks that this information is so urgent, he sends it to me on a Sunday night. Another very significant part of the chronology we learn on the day that Abrego is indicted, secretly behind the grand jury. That's when Schrader resigns. And on the day that Abrego is brought into the United States for prosecution, McGuire receives a phone call from Todd Blanche that's essentially an attaboy. He congratulated him. He thanked him for bringing the case. And you had McGuire saying, oh, that's pretty standard. And what he's calling standard is getting a call from the deputy attorney general thanking him for bringing this case that was, according to him, only brought with his sober, independent judgment without any interference from Maine justice. So what we have here.
So let me just say, I part ways with the opinion that that was pretty standard, that the upper echelons, the highest reaches of the Department of Justice leadership, but for the Attorney General herself, the Deputy Attorney General, the number 2 person, Todd Blanche, who also happens to be a former criminal defense attorney for the President of the United States, would just, be providing information, or his, chief of staff or his principal deputy, was that Singh?
Saying yes.
Yeah, would just, be dropping emails on a Sunday night about a cooperating witness in a very old, potential smuggling case based on a traffic stop. Listen, I don't know how gullible they believe Judge Waverly Crenshaw is, but let me say, I look forward to Judge Crenshaw making all important credibility findings about the testimony of the witnesses in this case.
Right. Absolutely. And because what we have here is, as I mentioned earlier, the burden is now on the government. It's the government that has to overcome the presumption of vindictiveness. And they brought these 2 witnesses, and they got these 2 witnesses to say that they exercised their independent judgment without any interference from Maine justice when Ms. Sode from the Homeland Security Investigations had said, when she was asked, had she ever spoken to Secretary Nome about it, she said, no, that would have been inappropriate. And you have these 2 witnesses saying, we made that independent decision. But to your point, Glenn, yes, it is up to Judge Crenshaw now to look at all the context, to look at the really funny timing, to look at the emails that I believe we discussed late last year that became public. It spilled into public view saying, wait for clearance. Akash Singh, Todd Blanche's deputy, tells McGuire, wait for clearance to bring this case forward. Mr. McGuire was asked about that email and claimed that he didn't know what he was talking about with the clearance thing because he wasn't waiting for permission. it seemed to be a little too cute a denial. And just to throw a question back to you, Glenn, one of the reasons that sounded strange is, of course, the vindictive prosecution hearing is about it being inappropriate for a main justice to give an impermissible reason to push for prosecution for a wrong motivation. But I don't think anyone ever thought that Robert McGuire was freelancing here. If it wouldn't, it seems more suspicious that he would say that he wasn't getting clearance from main justice. This is a big case. He in a normal case, and I guess this is my question to you as a former federal prosecutor. On a major case, wouldn't you get clearance from main justice,
Of
depending on the, depending
Of
on?
course, particularly when there are potentially politically fraught cases, we want to make sure as we are proceeding with a grand jury investigation, with an indictment, proceeding to trial, that we have the backing and the support of the higher ups at the Department of Justice, not because there is potential political interference at play, but because we want to make sure we're doing the right thing, and we've got the support of DOJ leadership in holding, what I call the ruling class criminals, the high profile people, the connected, the influential, the wealthy, the privileged class. We want to hold them accountable for their crimes. But if, there's going to be political interference, that makes things, it makes it improper because there shouldn't be. But the reality is we know that sometimes there is, particularly in this administration. So we want to make sure we're not perceived as going rogue. And of course, those things get vetted to the, highest levels of Department of Justice leadership. But as you described the testimony of McGuire, and is it Sode? Am I pronouncing that
So,
name right?
yes.
Sode. What it sounds like they're peddling to the judge, it's like the old Groucho Marx line, who you going to believe, me or your own eyes? And
Mhm.
when you talk about those emails that seem to suggest something contrary or inconsistent to what they're peddling to Judge Crenshaw, again, I fall back on credibility determinations based on what these witnesses are saying in Judge Crenshaw's courtroom are going to be all important. I think back to when Kash Patel testified in the 14th Amendment disqualification case out in Colorado. And he laid out a particular, story. And the trial court judge in Colorado said, I don't credit Kash Patel's testimony, which interestingly would result in him not even being a sponsorable witness, not being somebody we could ever put on the stand moving forward, because we would have to disclose not only to the defense, but the jury may hear that another judge found him to not be a credible witness. So credibility determinations by a judge are all important. Just because Sode or McGuire said something does not mean the judge is going to credit it.
Absolutely. And that's why I found that particular denial that they were waiting for clearance from main justice so puzzling. He didn't have to deny that particular thing. And there were other much more damning emails that came forward in December. There was one saying where McGuire had told his team that DAG, referring to the Deputy Attorney General, and PDAG wanted to charge this case as quickly as possible. And he had to try to explain away that message. He had to try to explain away the fact that he is receiving this apparently urgent email on a Sunday night right after he gets the case, and supposedly gets that case from Ms. Sode, but doesn't learn about the key cooperating witness from Ms. Sode. He finds it out from Akash Singh. So to your point, it's going to be that Groucho Marx routine that it goes to, mirror your own lying eyes, because we have two witnesses who have claimed that they've made an independent judgment that is contradicted by contemporaneous emails that where the timeline is a bit too cute, and where narratives aren't internally coherent. I mean, you have going back to Rana Sood's testimony from Homeland Security Investigations. She says once again that she learned about this from a small circulation conservative uh, publication, the Tennessee Star, at a time when this was a national conversation, at a time when Donald Trump was talking about it. So the story itself doesn't add up. But what we do have here with McGuire's testimony, he acknowledges that his friend, who was a former criminal division chief, uh, Ben Schrader, that he was an honorable prosecutor, an excellent prosecutor. He didn't think that the evidence of the case added up. It shouldn't have been charged. And by the way, Ben Schrader's longtime former deputy is now on Kilmar Abrego Garcia's legal team. It is Rasco Dean who cross-examined Ms. Sode today. And it comes
Wow.
full circle.
And, Ben Schrader, as the chief of the criminal division, let me just translate that from legalese to English. That is the person who sits atop and supervises all of the federal prosecutors in all of the different sections. For example, there would be a national security section, there would be a public corruption section, there might be a gang unit, a RICO type section. He is in charge of all of it.
Right.
And for the chief of the criminal division to resign over that office's decision to indict Abrego, I find dramatic and telling, and inferentially, it leads me to conclude he did not believe Abrego should be indicted. And that is pretty dramatic when, what's at issue is whether this is a legitimate or a vindictive prosecution of Abrego. So let me ask you this, unless there's more evidence for you to share with us, is the evidentiary portion of the hearing now closed, or might there be additional testimony taken in the future?
The evidentiary part of this vindictive prosecution process, the adjudication of it, that is now closed. What is still ahead is once the transcript is made official, both of the parties have 30 days to submit their arguments about whether this case should be dismissed. And then Judge Crenshaw will render his ruling on this. I think what was happening today was the building of an evidentiary record, because if the government loses and this case is dismissed, you can bet on there being an appeal. And that appeal will depend on an evidentiary record. It is extremely rare. We have not seen it in Trump 2.0. I haven't seen it in 2 decades as a legal journalist, that a case is dismissed for vindictive prosecution. So I think that you have Judge Crenshaw here giving the government every opportunity to put on knowledgeable witnesses to make its case that this case was brought for the right reason. And they chose 2 lower level people. They fought against the testimony of the higher level people. And now that record is closed.
Yeah, Todd Blanche resisted mightily, having to testify about what he did or didn't do. It reminds me of an old saying from a homicide detective who took me under his wing 100 years ago. He used to say, if you're scared, say you're scared. And, I would have liked to have seen Blanche examined and cross-examined, but I guess that was not to be. So the final arguments that the parties will submit, or the arguments on the motion, will that be in writing, or will they be making those arguments orally?
Those will be written arguments. So
Okay.
we'll see. There wasn't an explicit mention that I heard that we'll be back here. I'm still in Nashville right now, that we'll be returning to Nashville for oral arguments. I think that he's going to rule on the papers. I'm going to be very interested to see whether that memorandum that Ben Schrader wrote that he wanted to get sent to Maine Justice and other people, presumably at DC, maybe in the White House, about this, whether it's going to be referenced in the ruling, whether we're going to learn why Ben Schrader came to the conclusion that this case shouldn't go forward, and whether his opinions will come to light. I think the existence of that memo is one of the major takeaways here, along with the very curious timing. We learned stunning details about the timeline, about how this case came into fruition here today. And I'm sure it's going to be laid out there in a very clear narrative by the time that Judge Crenshaw writes his ruling.
Last question, which is a bit down in the legal weeds, but the Schrader memo, which now I'm going to call it moving forward, was it ever produced by the prosecutors to the defense as potential Brady exculpatory evidence that the Constitution requires prosecutors to give the defense counsel anything that would be exculpatory, that would make it seem like the defendant didn't commit the charged offense, or that might be extremely helpful to the defendant in presenting his defense? Was there any discussion about whether it was given over as Brady material to the defense?
So today was the first time I have ever heard about the existence of the Schrader memo, and there was no dialogue that I heard about its disclosure or non-disclosure. One would assume that it would have to be disclosed, and that if it hasn't been disclosed, we might be hearing from the defense about that in the near future.
Yeah, it feels like Brady information to this old prosecutor, information that constitutionally is required to be turned over as part of the due process rights of a defendant. However, the prosecutors would very likely argue, no, it's work product privilege, internal deliberations, and we're not required to give it over. That's the kind of thing judges resolve every day, those kind of run of the mill, not that there's anything run of the mill about this case, but run of the mill Brady issues that bubble up in, frankly, most criminal prosecutions. Adam, thank you for bringing all of that. That was fascinating. It makes me long to get back into the courtroom. I'm not going to lie, but please tell everybody where they can find you and your great work.
Thank you very much, Glenn. You can find my reporting on All Rise News here on Substack. If you want to go find it on the internet, I have a story on it right now, www.allrisenews.com. And All Rise News subscribers are the folks who send me to the courtroom, that allow me to, I'm New York based, to let me go to Nashville, Tennessee, where I am now, or Milwaukee, Wisconsin, where I was late last year. So thank you for bringing me here.
All right. And thank you for bringing us the inside scoop about what's going on in these courtrooms. And I'm sure I'm going to be calling on you again soon. So thank you very much, Adam.
Thank you so much, Glenn.
Take care, everybody. I'll see you a little bit later tonight.